Okay, thank you once again for joining the class. As usual, we will start the class by reading the what we call the factual circumstance given by the class by the question, and then subsequently I will teach you, maybe share with you on the ways to answer those questions accordingly. All right. So this is a top question. In order for you to do what we call a proper and a systematic approach towards this question, the first thing you should do is to identify what kind, is it a death or is it an injury issue? Try to get me properly. Is there any person died in this question or not? Very important because eventually you are going to use in top question per se, you are going to use Civil Law Act. That one, if somebody die, you have to use Section 7, dependency claim, or Section 8, estate claim. If nobody die, for example, it's just a mere personal injury, those claims are actually personal injury claims. So please distinguish the facts for said before you comment to write your question. Okay. Uh, and read and digest every single fact given in the question in full detail and thorough manner. Nothing in this question is being put just for fun. Okay, everything got its value. It's just that your ability to identify this, how to say, this piece of information given is at your is at your skills and also your knowledge lah. Okay, I will read the question as usual, then we'll go to the answering part. I think this class is going to approximately take about 1 hour and 15 minutes lah, maximum. Okay, first is about the facts of this question. Encik Sudirman Jama seeks your advice with respect to the following incident. He states, I want you to act for me, my son Shah and his girlfriend. Okay, so identify the key issues. Who are the plaintiff? In this case, probably Shah and also girlfriend. The name we have not yet known. Okay, in respect of an incident on 9 September 2020. So on 9 September 2020, what happened was at about 9 p.m. along Jalan Pasir Bokak, Bangkok, my son, Chia bin Sudirman, aged 17 years at that time, was riding motorcycle number ACE quadruple 4 with his girlfriend Zul binti Atan. Now you see the second plaintiff is surfacing. Okay, the name to appear already. My son, who was traveling towards Telok Nipah, made a U-turn and proceed towards Bangkok town in an attempt to escape from police as he was not wearing a crash helmet and had no license to ride a motorcycle. So what happened next? His girlfriend said, while my son was riding towards Bangkok town after having made a U-turn to escape the police for traffic offences, policemen chased him on a motorcycle number CAD 187 from the rear, came abreast of my son's motorcycle and kicked his motorcycle, and both of them fell with the motorcycle. Okay, so apparently there was some attempt of pursuit of police, and then subsequently, um, the plaintiff in the issue fell down and suffered from injury. So my son's girlfriend also said that the policeman who kicked their motorcycle, the first time he kicked, hit it right leg. The second time the policeman kicked it, hit the right rear side of the motorcycle. So there is an intentional act part of police. Tendang satu kali, kena kaki. Tendang kali kedua, kena belakang motosikal. So there's an intentional act of the police. So what happened next? My son then lost control of the motorcycle and they were both thrown off the motorcycle onto the road. She then became unconscious. She suffered injuries as per her police report dated 10 September 2020. My son suffered serious injuries and now he's now a paraplegic and is a wheelchair dependent for the rest of his life. He's now staying permanently with us. He cannot move. My son was readmitted to GHKL from 30 May 2021 until 31st May 2021, where he underwent further surgery on his buttocks due to bad sores as his skin had become rotten. So this guy totally cannot move already, becomes paraplegic. He cannot sit for long as he has to lift his buttocks. My son had his crash helmet with him, but he did not wear it. Okay. So subsequently, what happened? According to the policeman, my son lost control of the motorcycle as he was riding at a fast speed in an attempt to escape the police. The police had seen him from a distance that my son was not wearing a crash helmet. So it's an offense here. Lah. He's not wearing helmet. The motorcycle belongs to me. I have spent 500 ringgit on repairing the motorcycle. I have brought when he consult you as a lawyer, he brought the following documents. Number one is the police report by Zul binti Atan. So the identity is clear here, is the girlfriend's okay, police report. And also alongside they have specialist report by Dr. Dushan from GHKL, as well as one police report made by Lance Corporal Azmi Ahmad. So from this text alone, okay, the defendant names only surface towards the end of the story itself. Okay, so roughly you make out, okay. And then we go to the relevant documents as provided. Okay, first thing here is the police report. Roughly, you see the full name as well as the date that make the police report. What are the identity? Just at a glance, you can make out. So the same story will be reiterated inside this police report. So basically, it's the same. 9th of September, they both ride a motorcycle. Okay, the plate number, everything is confirmed, and then police, there's a roadblock. Okay, and then they turn. Subsequently, one policeman chase them and kick. So you see or not? These are the tally facts. Okay, so this is the police report. This medical report itself, what is the value of these medical reports for your top question is that you need to draft your statement of claim according to the particular of injuries as stated inside this comprehensive medical report. So these are the full version from the medical doctor to state what kind of injury that the victim sustained from. Very important. Basically, the tips here is you will not have time to digest the anatomical or what we call scientific term. You just copy and cut whatever the version and change a bit, then you becomes a very well drafted statement of claim. I'll show you later. So basically, this Shia here has sustained from the injuries listed in A, B, C, D, E, and then subsequently they tell you what is the prospect of recovery and does this person or victim need further nursing care or any other medical expenses incurred in the future or not. So this is what you have to make up. The story told by the father cannot itself disclose you the full picture of what the victim sustained from. But somehow or rather, if you read it from here, then probably some awards of damage, for example, pain and suffering, loss of amenities, you can rely on the facts provided here to make up the claim because the injuries was ruining his life. You can make out, isn't it? You can get what I'm telling, isn't it? This is how you use these reports given to make your answer standing out. Okay, very important, eh? And this is the police report made by the defendant. Okay, so this is made by Azmi Ahmad. But this evidence, if you scrutinize carefully, when was the evidence being made? You see, all the reports, police report, is a contemporaneous version of report, isn't it? So to make the relevancy, this one, of course, to make your answer stand out. If you don't put, I don't think it's such a big issue. This one is made 10 days, almost 10 or 11 days after the incident, It's more, if you want to argue, it could be an afterthought. That means pemikiran semula. Dia tengok, dia sudah buat salah, lepas tu plaintiff sudah cedera teruk, baru dia fikir-fikir macam mana nak draft satu police report. So this one contemporaneity, the time that make the police report got one problem, they purposely put to challenge whether you have the sharpness or not to become, because lawyer you need to seriously in practice you have to scrutinize the documents provided in a very tedious manner. If not, uh, you'll get a lot of surprise attack. Okay, so he told the version of the story roughly. I think we can cross match with the plenty version. Basically, it's just a pursuit, and then some tragic incident happened during the pursuit. But somehow or other, this police report blame the plaintiff. It's their own fault, not wearing helmet, and then they themselves ride fast, and then he did not identify or volunteer any information that he kicked the fellow. You get me? So this is the contradictory part of this police report, because obviously the defendant would not uh, offering some information that incriminate himself here. Okay, but later on we play out we see how to play out those evidence Okay, first we go to the question. What is the first question asked by the examiners? Okay, A, you are to comprehensively advise on the possible causes of action. See, causes of action, bukan satu. Ini banyak tau, that arise. Your advice should also indicate any defenses as to the liability available to any person or persons identified as a prospective defendant or defendants. So, in every civil case, you have to first, before you actually commence a civil suit, it's very important for you to have a checklist. What are the checklists? Number one, you have to identify who are the parties involved. Siapakah yang patut dinamakan sebagai plaintiff? Siapakah yang patut anda namakan sebagai defendant? Seterusnya, you have to identify apa kosa tindakan di sebalik you punya writ of summon tu. Okay, what is your course of action? And then subsequently, you have to go to a few preliminary things, whether your action is barred by limitation, and then your action is actually not suing the right parties, etc. So you have to go through a few preliminaries. But here, you have to direct your answers into usually question A, just number one as an introduction, isn't it? Make your answer standing out. Identify who are the parties first. Who are the plaintiff and defendants? So I hope I make myself very clear. First and foremost, it is important to determine the civil action. Okay, parties. Who are the plaintiff? And why you say he is the parties? Very important. Okay, so first we identify two plaintiff here because two persons suffer injury. Boyfriend, girlfriend. But boyfriend got one problem. Boyfriend now paraplegic. He is not able to be coming to court as a competent person. He suffer from person. He's deemed to be a person under disability. So you have to put something like that. Okay. So Injek Sudirmai Jamal is suing as the litigant representative. Okay. On behalf of his son, Shia bin Sudirmai, who is a person. Wait, somebody's asking whether we have class or not. Okay. Uh, anyone can join it. I mean, I didn't realize there are so many waiting rooms. So sorry, so sorry. I have to apologize because I neglected some of you because I seriously that's why my WhatsApp keep on buzzing. Okay, so sorry, but you are not too late yet. I just finished reading the question, and okay, we can continue the class. Okay, who are the plaintiff? Encik Sudirman Jama is suing as the litigant representative on behalf of his son Shia bin Sudirman, who is a person under disability pursuant to Order 76, Rule 2, Rules of Court 2012. Very important, eh? So this Shia paraplegic, I already said, he is person under disability. And second plaintiff will be very simple, Zur binti Atan. Okay, who are the defendants? The defendants, the prospective defendant will be number one, Azmi Ahmad as the Royal Malaysia Police, okay, PDRM, as well as the government of Malaysia. As a prudent and reasonable lawyer, you must be able to dig out what is the most beneficial approach for your client. If you sue Azmi Ahmad, what will end up will be you will probably get a paper judgment. He will not be able to pay for the negligent suit. Okay, for example, the cost like 400,000, 500,000, he will declare bankrupt. So at the end of the day, you'll get a paper judgment. Nothing is beneficial to your client. So you have to sue the government of Malaysia because the Ministry of Finance will pay. Okay, Malaysia government cannot go bankrupt. If not, we also in problems, isn't it? Okay. So the causes of action in this action will be discussed with respect to each defendant as well as the ingredient or element of tort. Then simultaneously, you have to guide the examiners. What is your further argument? What is apa you punya pujangan yang seterusnya? Okay, very simple, eh? And then subsequently, you have to identify what are the possible defenses to the said causes of action will be explored. So you go one by one, one by one. Okay. I saw some question in the chat box. Maybe I can go through it later and answer accordingly. So first, make it very big and strikingly obvious to the examiners that you have state Azmi's liability. What is this problem? One by one, you argue your answer, don't jumble up. Later, people cannot understand you. Okay. So first thing first is it is you can derive from the facts that this policeman hit Shia, okay, and also kick the motorbike, isn't it? Causing the injury. So there's an issue of trespass to person, specifically battery. Okay, identify this issue. As a police officer on duty, he committed battery as a tortious element below are fulfilled. First, trespass to person, unlike negligence, trespass to person is an intentional tort. you do it with deliberation. You purposely buat sesuatu. Okay? Nak pukul orang, nak lempang orang, nak sepak orang. Something you do with knowledge lah. It's not something accident. Okay? So intention element, how you want to argue? Okay, the key point here, okay, first, you must say there is element of knowledge lah. Because takkan tak tahu kalau you sepak dia akan jatuh. You know, isn't it? Okay, so kick Zul and also motorcycle leading to their falls and injuries. So it is an objective evaluation here. Okay, Azmi hit plaintiff dua kali leh, bukan sekali. Sekali maybe you don't know lah. I mean twice. How you want to argue? This is a concrete proof of his intentional act. Okay, so this one you can get me. So battery involve direct contact. You did touch the body lah, okay? Or you didn't touch the body, but subsequently the contact itself is in the similar transaction that caused the injury. So get your laws very, very good, huh? Okay. Just give me 1 minute, 1 minute. Okay, so sorry. Okay, where will we? Okay, there is a direct application of force. Can still hear me, isn't it? Okay, so causing by Azmi, leading to the accident. Okay, so very important. And the third element of this thought will be without consent or any lawful justification. So you must, in a manner, argue that Azmi's application of force is actually unreasonable. It was type of excessive and not necessary type. He's not under threat, isn't it, Azmi? Azmi as a police officer, the motorcycle is U-turn, It's different version if the motorcycle is actually trying to bump the roadblock. So it's a different type. If you bump, they can shoot you. Okay, that is the reality lah. They can shoot you, but they make U-turn. They want to escape, so you stop, you shot. What kind of threat that possess to you in the first place? So there is no one. You can argue that both plaintiff, neither Zul nor Shah pose an imminent threat to the officer or public safety. So this tort itself is committed unlawfully. So you can rely on one case here, Tan Agao against the government of Malaysia. And second liability or second cause of action that you can make out from Azmi will be negligence. Okay, negligence, how you want to argue? Based on the scenario given, negligence is a must test area lah. Confirm dia akan keluar lah. So this one you have to memorize very well and how to draft your answer nicely. So it is evident that Azmi had acted negligently towards plaintiff. The plaintiff are required to satisfy the four elements below to establish this liability. So you have to factually tailor-make your answer. Don't regurgitate just, oh, duty okay, the neighborhood, the kemas, the haro has all that you put, everything, but you do not relate how you want to advise your client in such a way. So no need, you have to advise it like a professional lawyer. You talk so much, the caparo, people cannot understand. So you make it simple. So as a police officer, why there is a duty of care exists is because of the nexus of the parties. Ask me, all a duty of care to safeguard the plaintiff as good users and citizen of Malaysia. What is the Malaysia punya police what we call their duty is to protect us one to protect the citizens of Malaysia. So applying the neighborhood principle in Donahue against Stevenson, there's a cross from proximity of relationship between Azmi and plaintiff, namely Zoe and Shah. Full stop. Don't write anything further because you have more to answer. Okay. Second, the said duty of care must have been breached. That means to say, that tanggungjawab ataupun kewajipan tersebut telah dimungkiri oleh defendant. So, how you want to argue based on your fact? A policeman in pursuit, okay, tally with your facts, owe a duty of care to the suspects he is pursuing. Make it sharp and clear. The standard of care for such policemen and in such situation is to exercise such skill and such care and skill as is a reasonable, the thing is still back to reasonableness test. But just that you already reformulate your answers based on fakta case name. In this case, the act of Azmi in kicking the plaintiff motorcycle who was riding at a fast speed, even though he was attempting to escape police detention for police offense, was most unjustified and unlawful. Okay, if you are interested, actually the facts of this case after my later research is from this case. Sarijan Sudirmin and others against Abdul Rahman Roque and others. You can Google and see this case. Exactly the same. Okay. Causation. The third element. So both plaintiffs had suffered bodily injuries as a factual consequences of the said breaches of duty. So you use but for test. The damage will not have occurred but for the particular fault. Then the fault is the cause of the damage. Okay? Oleh kerana. You get what I'm saying? Okay. Conversely, if the damage would have happened just the same, no fault, then the fault is not the cause of the damage. Okay, a little bit tongue twisting. If let's say the patient is going to die eventually, not whether the doctor intervene or not, cannot be like negligent because he will die, or the person is actually riding motorcycle, actually he fell by losing control at that speed, then there's no liability of negligence on police, okay, so this is Bernard against Chelsea and Kensington Management Committee. Okay, and furthermore, the last element is damage. The plaintiff have suffered physical harm and economical loss due to the damage. Okay, highlight this is thought you have to identify what kind of victim is this. Whether it is just primary victim. Primary victim is very simple. Physical harm. Okay, whether it comes in what we call usually physical harm. Okay, if let's say secondary victim is some sort of nervous shock, you watch TV, then you got post-traumatic stress disorder, all kind of thing. That one is you become oversensitive, lah, not me for being negligent. And the damage itself must be foreseeable as outlined by wagon mold test. Okay, the damage must not be too remote. Okay, that one is very important. The principle established by this case revolve around the concept that the defendant is only liable for damage that he was reasonably foresee as a consequence of the action. Okay, in this manner, you can further elaborate your answers. The accident is not too remote. Actually, you can predict. If you kick, the motor is going to fail. I mean, the plaintiff is going to fail, and then subsequently, they will suffer from some kind of injuries. Okay, And if let's say, for example, if you are seeing all this the public authority, and then you feel there's negligence or misconduct on their part, do not simply argue breach of statutory duty, because breach of statutory duty by law is just defined that you breach certain specific statute. With reference of this case, the statute that you should refer to, because the defendant in issue is police officer, you have to rely on Police Act 1967. So even we in practical field, we also need to go back to the specific section. You don't try lah. You don't try during examination to argue this lah. Okay. But anyhow, for your sake of knowledge, there's no breach lah. You refer to section 20. Actually, everything seems okay. And defenses available to Azmi. You discuss systematically. Defendant, defense, because different. Okay. Section 2, Papa 1978. Okay. You see, Section 2 Papa itself is an absolute bar. Okay? That means to say, if you are suing government or any public authorities, and then you miss the period 36 months, isn't it? For negligence, isn't it? Okay. Then your action cannot be sustained at all. Okay, so you see, the accident actually happened 9th of September. Okay, the date of consultation is your date of examination, 6th of November, based on whatever I got from this paper lah. By virtue of Section 2 Papa, 36 months is already lapsed. The limitation here is absolute. Unlike your limitation act, you can actually stretch the time based on a few factors like fraud, latent defect, all this kind of issue. Papa, no room for negotiation, no room for further discussion. Bar mean the whole action thrown out. Okay, so you can see here, Hop Chai Sosotikul, okay, the waris of Bumsum Bunyan case. This one is your indivisibility issue land case lah, very important, against Pejabat Tanah dan Galian Pulau Pinang. Okay, this is an absolute bar towards the claims of the plaintiff. But you see, Section 2 Papa here only talks about negligence. But our cause of action got what? Got trespass to person, isn't it? So you have to somehow or rather think a little bit further. Is it sudah mau gulung tikar? I mean, sudah mau tak ada case balik rumah ke macam mana? So you draw an analogy to famous English case of Letang against Cooper, where plaintiff face similar time bar limitation. But this case is the balik. Negligence is bar. Trespass to person to are not bar. Okay, so he plead in alternative. Okay, so the ruling in Letang here, okay, clarify that negligence and trespass to person are not mutually exclusive but distinct. You see, they are different, although there are some overlapping elements. Because tort, if you are interested, you can go back to my YouTube channel. I have talked quite detail on the top element. Somehow or rather, there are some overlapping elements over ingredients of top. Okay, you're interested, you can go through yourself lah. Okay, based on the nature of the defendant's conduct and directness of the resultant harm. Therefore, based on this judgment, I will still argue, not absolute yet, still have room to initiate action for battery, which is not barred by Section 2 Papa. Okay, so this is your first point of argument. So second issues that you have to identify is contributory negligence. So according to the facts given, Chia was riding without a license and helmet with full knowledge. While Zhu was a pillion rider, she seems to know that the fact that Chia was riding the motorcycle illegally. So both plaintiffs are partially at fault in this matter. They are both blameworthy. Okay. Nevertheless, Section 12 of your Civil Law Act 1956 specifically provide that contributory negligence is just a partial defense. It does not absorb Azmi's liability in totality. That means, yes, the plaintiff partially wrong. They are wrongdoers, but it does not actually stop the action at all. It just gives discount of the action. Okay, you can draw again analogy to one case, Go Bang Sang against Dol bin Dollar, whereby probably when you are advising the client, in this case, the court might apportionate the total amount of damage awarded based on the degree of fault of the party. For example, 80% ASV paid lah, 20% discount on part of faults due to plenty. This is how it works, huh? Okay, the third element that probably the defendant is going to raise would be lawful authority. I am performing the duty according to the law given. I arrest the parties with force, and then because I can say the plaintiff is on the run, so I have to apply some force to make the arrest. So this is under your section 23 of your CPC and section 21 of your Police Act. Okay, so further argument, this one, of course, I don't expect you to write during exam code. Roughly, okay. Subsection 2 of your Section 21 Police Act specifically say that any person who obstructs, opposes, disobeys any reasonable direction given by police in the performance of his duties shall be an offense. Okay? And those person commits an offense can be arrested without warrant. Okay, you see, not wearing helmet is just what we call compoundable offense. It's not carrying drugs, it's not murder, isn't it? So the person want to argue further, you have to put in some law. You run away, why I can arrest you without warrant? So this is the law behind that, lah. Okay. So unless he provides his name, okay, then in this event, you relate back to the facts. Okay, what are the possibility defense that can uh, uh, voice up by ASV? In this event, both of the plaintiff were escaping and deviant from the instruction and or instruction given by police, resulting in the pursuit. Police ask you to stop. You U-turn. You try to tekan minyak lagi. So, macam, which ended with an accident. Azmi could plead that he was exercising the lawful authority as a police officer. So this is one challenge to your case lah. And last but not least, this one is very important. Act of illegality by plaintiff. This maxim here, ex terpi causa non oritur sure. Both plaintiff were actually involved in some kind of dishonorable, unlawful, what we call activities. They are this fellow, especially Shah, he's not driving with license. He's illegal, macam mak rempit. Okay, he's not wearing helmet. If you come to court with dirty hand, by right, justice cannot be served. Like I escaped, I'm a drug trafficker, go and smuggle the drugs. Then subsequently, the police shot me during the pursuit. It served me right lah, because My hand are all dirty what. There's tainted some tainted issue, Okay. So here both plaintiffs were involved in illegal activities when the incident occurred. The first plaintiff lost control of the motorcycle as he was riding at first high speed in an attempt to escape from the police. Okay. And some more important part is other crash helmet and then did not possess a driving license. So it is contended on behalf of the defendants that the plaintiff is actually the author of his own misfortune. People say, serve you right. You punya ni lah, rezeki lah. You sendiri buat salah, you punya rezeki lah. So the defense has pleaded this one lah, ex terpi cosa non orito actio. No action arise from an act that the law forbids. So these are the defenses that could be raised by the defendants. Okay. And next, we will examine the second defendant in this question, which is the government of Malaysia. Okay, government of Malaysia, I saw one question, why we don't name PDRM? Actually, we don't name PDRM because PDRM is not the so-called the party to be sued in this case. So if you read your rules of court thoroughly, you can sue individual, you can sue partnership, you can sue sole proprietorship, you can sue society, you can sue state to apa negeri, you can sue government of Malaysia. TDRM itself, usually no, I don't see anyone the what we call name them as a party. Eventually, you must know who employ, siapa boss dia, siapa boss police. Like government doctor, we don't name like Hospital Sultana Amina or GHKL as our defendant. No, we name government of Malaysia straight away. Okay, vicarious liability is the what we call the cause of action that we want to sue the government for. Okay, it refers to a situation where a party is held liable for the actions of another party. In the context of employment, it particularly refers to employers being held responsible for the actions or omissions of their employees if such actions occur in the course of their employment. Okay, you must know one point here. Vicarious liability, we are not concerned with whether the government had done anything wrong or not. It is a form of strict liability. Liability ketat. That means your employee buat salah, boss kena tanggung. Okay, tanggung risiko because you hire them. Okay, so applying the laws to the current case to establish the claim of vicarious liability on the government of Malaysia, plaintiff bear the burden of proof for the prerequisites below. First, you have to establish, is there a relationship of employer and employee or not? So clearly, do not say the law, say why you say so. Azmi is clearly identified as an employee and an all public servant of government of Malaysia, serving actively as a police officer. You can even state his post Lance Corporal. Okay. Second thing, the act itself is not on personal capacity. It's happened when he was employed to do the job as a police. You can understand, So you say the key factor is whether Azmi action was taken in the course of his employment or not. Given that he was executing his duties as a police officer during the incident, it is evident that his actions, though reckless, were performed in line of his duty. Yelah, dia buat kerja, dia roadblock, but he performed out of scope. Is it still cover? I will say yes, because I am for the plaintiff. Okay. And then second thing, the negligence must have occurred on part of the employee. So the employee must be caught liable, then only the vicarious liability can be established. So I will submit as such, the actions taken by Azmi raise significant question about the standard of care expected of a police officer. The duty includes not only enforcing the law, doing so in a manner that does not unduly jeopardize the public safety. You see, not everyone roadblock, people run away, go and kick, isn't it? Not everyone, every police officer will do, isn't it? So by allegedly kicking the motorcycle in a high-speed pursuit, Azmi clearly breached this standard. In another word, Azmi is negligent. Okay? Simple, eh? So it is worth noting that vicarious liability is a form of street liability. What I already said, the government not necessarily at fault. However, due to the negligence committed by the servant, automatic liability shall be imposed on government of Malaysia. So you can refer to apa nama one case here, Union Insurance against Chan Yo Yang. Okay. So far, are you all good? I mean, are you all still with me? Can understand what I'm trying to explain?
Yes, yes.
Okay, very good, very good. Okay, the defenses are available to government of Malaysia. You must read between the scope lah. You cannot just regurgitate again. Yeah lah, I know the section 2 papa contributory negligence you already discussed. You just put this way lah, aforementioned, aforesaid, as discussed above. Okay, to show that you know, because sometimes there will be presented by two separate lawyers. You have to draft two different statement of defense. Okay, one section that you have to put your attention into is section 5 and section 6 of Government Proceeding Act. When you have a case against government, okay, there are certain rules. You cannot simply because you know Ministry of Finance is there a lot of need money, so you simply gas up them every time. So it is governed by Government Proceeding Act 1, you know. Specifically, Section 5 talk about liability of government in tort, you know. Okay? Now you see, this Section 5 here state that the government is liable for wrongful acts, neglect, or defaults committed by any public officer in the course of their duties to the same extent as to private principal will be liable for the actions of the agent. Okay? An agent of government here, public officers who act or purport to act in good faith under a duty imposed by law are considered agents of government. This means they are deemed to be acting under government instruction when performing their duties. Okay, that means to say the case here Azmi, memang lah, he got the instruction. The government itself, you cannot identify who are not the prime minister give orders, you know, usually the sergeant lah, I mean the team leader of the police will give awak pergi buat roadblock lah, something like that. So you must identify, you know, but this is deemed to come from uh, government. And section 6, okay, limits of liability. The proceedings against government based on liability can only be initiated if the same proceedings could have been brought against the public officers personally. Okay, very important. You cannot sue PDRM. You cannot sue, like some case I've seen, ketua ketua police, the IGP, Inspector General of Police, Tan Sri so, like that. You sue like that. Actually cannot. The personal liability of the person that involved in the incident should, number one, ask me first. Okay, so reliance to the law above, how you want to say? Government of Malaysia may argue what, you know, ask me by kicking the plaintiff had acted beyond the instruction. If I'm the lawyer, surely I'm going to say so lah. Not in good faith and entirely in his personal capacity. Saya tak tahu. Dia buat atas dia punya kemarahan rather than performing the role and function of a police officer. One of the defense lah. Okay? Huh. And in the humble conclusion here, this civil suit is quite complex because you can see Azmi, you have two causes of action and also a vicarious liability. And how you want to conclude is by each defendant's actions and responsibility will need to be meticulously examined in the lights of evidence tendered by parties during trial. Okay, so this is my way to conclude now because I don't want to leave my answer hanging. You cannot also say that, oh, based on my assessment like that, Xia and No sure win like that. How you know? You cannot you cannot just give to some conclusion that you yourself are not very sure, isn't it? So you have to conclude in such a way now based on evidence. Okay, and B, you are to advise on the various items of damages claimable as a result of the incident, explaining carefully how such damages are assessed by the court. You are to advise on the principle relevant to the assessment of damages in this case. So 10 marks. Okay, I, I'm going to share with you one tips. Let's say you have really argued in a very thorough manner and you have spent so much time and then you see you only have 40 minutes. Don't do this question first. Go to your statement of claim. Don't skip this. Skip this and put it at the end. Because later you argue you non-stop writing, then you miss your statement of claim. I think sayang lah. Because statement of claim in this question give you 20 marks. So for you to pass, actually not easy. They won't give you like you argue like this. Probably my answer like this, they'll give you 10 marks. For you to get a B in a CLP exam, probably you can win the what we call the student award already. So this is the high threshold inside the examination. So don't bother to go and fine tune every single words. Wow, later you run out of time, then you fail. Okay, not worth it. So the case involves Shah and Zo's personal injury claim. So identify what type of damage that you are looking at. So the said damage shall be discussed based on the few headings. I'm going to discuss like that lah. That is my certain standard answer. So special damage, okay, special damage and what we call damages is different. Damages money, damage uh cover for the loss that you suffer. So the proper wording here is damage. No S, the other plural. Okay. General damage, special damage quantifiable at the time of filing. That means you have all the receipts and proof. This is special damage. And second is the general damage will be assessed by the court. And interestingly, for this sort of case, you think too much, you can actually put in aggravated damage and also exemplary damage. You want to teach a person a lesson to this society, to the whole, no offense, PDRM, so that they learn a lesson from USP and will not repeat the same again. Okay, cost and interest. So these are the heading. Don't just discuss these two, then habis 5 marks you get or even less. Okay, so these are the money claimable. Special damage refer to past medical expenses. Okay, prior to the trial, at the time of filing, inclusive of all the medical bills, hospitalization, surgeries, medication, rehab, equipments, etc. All the bills are you include, okay, substantiated with receipts and medical reports. And cost of care, because you see, Shah now handicapped, isn't it? To live together with family members and need professional caregivers. Okay, these are the current cost of care already out of pocket wasted expenses. This one, you put it here. And nursing care, also same. Okay. Logistic expenses. Okay, this one we love to claim now. And vehicle repair costs. So it shows that you read the question provided by the examiner, the RM500, and also the cost to produce these medical reports, and also the RM2 for the police report, and also medical report, especially report in Malaysia, RM80. So these are the costs that you can claim under special damage. Okay, with sufficient documentary evidence, such bills, receipt, and also what we call whatever evidence you can produce and you can tender to the court, those special damage is claimable. Okay, second, we look at general damage. Okay, general damage refer to the damage that you cannot at this time produce, but it is going to happen and to be assessed by court. The court, mahkamah akan membuat taksiran terhadap apa kerugian yang berlaku. Okay, taksiran that one is assessed lah. Okay, so future medical expenses, surely, especially in the condition of Shah, very obvious, isn't it? Shah will need future medical expenses, paraplegic, you see bed sore repeatedly, probably you will need some special nutrition, etc., etc. This is future medical expenses. You can refer to the case of Chia Yi Chun, okay, as well as pain and suffering. What are the pain and suffering endured by Shah due to the injuries sustained? Okay, these will comprise of emotional and also physical pain because it's not easy, Like suddenly you're normal, then you become cannot move at all, but somehow or other, God only knows whether your brain is still functioning or not. You can perceive the pain or not. So the severity of his injury, the duration of his suffering, and impact on quality of life, okay, shall be assessed. So which section? Section 28A, subrule 2, subrule B, provide that Shah's, let's say the life expectancy, by right, 17 years old plus 35, he can barely live to 52 years old, So that means to say, by right, average Malaysian can live up to 74 years old. Wow, he 22 years shorter, like that. So this is one form of loss also, Okay. And Zul's pain and suffering due to the injuries because he fell down and then he got kicked, isn't it? This one also will need to be assessed based on medical reports. But unfortunately, we do not have any useful information in this question. But you highlight this, okay? And loss of future earning. Loss of future earning here, Shah's permanent disability will significantly impact his ability to earn. But however, you can see, to for you to fulfill this limb of claim, you cannot simply say that, oh, he's going to work next year. He's going to pass his SPM. He's going to work under his father as a farmer. He's going to earn 3,000. You cannot just say like that. So this issue here, two limbs must be what we call, must be discussed. Less than 60 years old, I already highlight the age 17 and the material time. Okay, but somehow or other, you see or not, he is not earning. He's not actually earning. The word here is benar-benar ada pendapatan. Okay, pendapatan. So, section 28A, subrule 2, subrule C, subrule 2, Roman 2, Civil Law Act cannot be applied to Xia, okay? According to the case of Chang Ming Feng. Okay, don't spend too much time, write so long name, all that, okay? And loss of amenities of life. Loss of amenities because you lose, actually the life, for you to enjoy lah. Frankly speaking, also actually you no need to read also if you are born rich lah. I mean, life should be happy. Ma. Reading, studying CLP is painful. So you have lost a lot of amenities of life for studying CLP. So same thing apply to Xia. After the said injury, okay, he is not able to perform the function as a normal human being. He cannot involve in sports, go movie also cannot. I mean, involved in any hobbies, overseas traveling, all tak boleh. Okay, it is obvious from the medical reports that Chia cannot longer lead a normal life due to his condition. So he is entitled, to claim loss of amenities. No more fun in his life. He's backbound, dependent, go toilet also insert catheter, diapers, and etc. So no fun anymore. Okay, worse than dying. So future cost of care. This one also very importantly, the cost of care provided to Shah by family members or even professional caregivers since the incident, as well as the anticipated cost of future care, is claimable. Okay, based on medical reports, it was alleged that Shah is dependent on others for activities of daily living. He will be getting the cost of care as of his right lah. So the calculation formula, because this is just one small title. I know many of you will be interested to discuss multiplicand, multiplier, all that. In my personal and humble opinion, since the mark is 10, you may as well as discuss on the interest and cost to show that your scope of coverage is more than other students that did not join my class. Okay, this is for example, you just maximize the claim in issue. No need to multiplicate all that. Just the doctor said he's going to live 35 years times 12 months, berapa monthly. One very basic formula. This will be the max lah. Okay, no need to calculate anymore. So aggravated damage. Okay, this is a new heading. You can see special general damage kita sudah lebih kurang habis. So we move on to the aggravated damage. Aggravated damage only will be considered in very special circumstance after the court buat taksiran. Calculate macam kurang lah. Ini dia punya claim macam tak berbaloi lah for the plaintiff that suffer loss. Then court will go in equity principle lah. They want to do justice lah. They want to reward the plaintiff lah. So the general damage is not able to meet the degree of harm suffered by the plaintiff. So this one aggravated will come in. Dr. Hari Krishnan, this one is actually medical legal case. Dr. Hari Krishnan against Megat no Ishak case. Okay, very important. This landmark case. Exemplary damage. Okay, exemplary damage. This one you must be able to give because the police is really too much right? I hope you agree with me. So the defendant in the suit had outrageously performed his statutory duty without reasonable training and skill. He had attempted to kick plaintiff down from the motorcycle, which would ultimately cause plaintiff to sustain serious injury. I will submit so. This was just a routine check and stop patrol the police was performing. However, the defendant had been doing it in a very terribly wrong manner, and therefore the outraged police officer shall be penalized. See or not? Okay, penalized under exemplary damage as a lesson to other police officers, so to deter them from repeating the same mistake in the future. That means to say, stop civil wrongdoing other than uh, restitution principle. I hope you know, restitution, restore the position back to original position. Okay. Other than restitution, there is also deterrent principle in our tort law. That means you want civil wrong action on balance of probability one, to serve what? So that especially professional or the public servant to behave themselves. Okay? Something like that. So other than above, other relevant claims are inclusive interest. Okay, interest got two tiers lah. Okay, first is the date of accident from 10 of sorry, this one should be 9 lah. Okay, 9 of September 2020 until the date of award or judgment paid out. Okay, so the power to award this interest is actually provided under Section 11 CLA. Okay, and also there's a second tier here is the interest award between date of judgment or award till payment. Take for example, this trial concluded 20 today lah. I mean 5th of June 2024. But somehow or rather it take 1 year for the defendant to pay. So in between 1 year, this judgment debt is chargeable with interest, Okay, this is provided under your Order 42, Rule 12 of your Rules of Court. So two tiers of interest you can claim, and as well as the cost. Okay, the cost usually is siapa kalah dia kena bayar lah. Okay, cost. And for the court to assess, um, the court will see whether you cooperate or not, you admit liability, who are the expert witness involved, whether there's a lot of interlocutory application, whether there's a lot of you involve forensic route traffic as the expert inside the trial or not, the length of the trial itself, how much energy and time the lawyer put in, etc., etc. Okay, so those are the consideration. There's no strict rule. The court will consider under the order 59, rule 16, rule 1, rules of court. Okay, usually based on the complexity lah. Okay, so should the court rule in favor of apa nama, it's not CLP lah, in favor of the plaintiff, so the plaintiff will entitled for cost. Okay, as simple as that. One more thing, one more thing very important. A lot of students seems to miss this part out. You must also consider whether specific relief act, the small statute that you are being provided during examination, will be useful or not to make your answer stand out. So this is particularly you want an apology from PDRM or not. But of course, this is not our case here. Lah. You cannot seek injunction from government. Okay, so that means to say, kerajaan cannot be asked in civil court to apologize. Okay, this is just this one don't misquote me. I put it quite big here. Maybe I can put a highlight. Okay, next time in your civil, contract law or the tort against private individual, is there a necessary to seek for apology? Sometimes in practical manner, we do ask for apology one. We ask them to draft an apology according to what we propose them in their official Facebook, something like that. So this worth for you to open up your mind a bit. Okay. And last question, settle a statement of claim to be filed against the persons or persons liable for such damages. Okay, they didn't ask you who are the party, so presumably we go back to the first sentence. You see or not? I want you to act for me, my son, Chia, and his girlfriend. So that means to say the parties only two lah. Okay. So how I'm going to draft 20 marks cannot just draft a template version. You have to put in facts because statement of claim here is very important. because you are bound by the four corners of your pleading. You cannot simply later on, wow, you don't plead, but subsequently you raise it during trial. Tak boleh, I will stand up and say, no, you cannot raise during the trial because you didn't plead. That's why you have to drop a nice and a very, very thorough statement of claim. Tak boleh cincai bocai, eh? Okay. So if let's say, for example, I will put it this way, lah, the way that I'm looking into it, in order for you to determine which court has the local jurisdiction and also the monetary, the award type of jurisdiction, you have to see what type of claim is that. Usually, RTA in Malaysia, road traffic accident, session court boleh award any quantum. Whereas if let's say is some private matters other than road traffic accident, okay, and also apart from your tenant and landlord dispute and all that, you can more than 1 million you have to put in high court, okay, and nearest to the defendant. So this is your what we call your rules of non-convenience. It's a doctrine of non-convenience. You heard it before, eh? So you have to choose the place where the defendant reside, okay, or the cause of action occur lah. So you just justify. Okay, so the incident, this one also I checked. I did this what we call the whole question yesterday only. They might be what we call mistake. You double check also. So I found that Pulau Bangko itu Perak punya tourist place they do not have a session court. The nearest session court actually Sri Manjung. But subsequently, I refer to the portal, because I don't want to misquote you all, isn't it? The session court in Sri Manjung, please correct me if I'm wrong. They only provide for criminal jurisdiction. So I think the what we call Telok Intan is the nearest session court available, okay, to the defendant. So I put it this way: in the state of Perak Darul Rizwan, Malaysia. Okay, make it very you have to put Malaysia also. You have to put cannot Perak, full stop. You have to hafal the Darul Ehsan, Selangor, Darul Taksim, Johor, something like that. You have to put there. You cannot simply just say in the wilayah Persekutuan Kuala Lumpur, full stop. You have to put one comma Malaysia. This is the latest format. And civil suit number, the top /2024. This is the right format with underline. You have to follow blindly this the format given. Okay, I will send this slide to the groups that don't worry. So between all that tak boleh lah ni like that. Later the pendaftar will cancel it out. They'll ask you to file an amendment. Lagi susah awak. Okay, so this one's name, spelling, all that you must be able to write in usually apa capital letters. Okay, Zur binti Atan as the first plaintiff, and also Shah bin Sudirman. Just now we have explained already. Suing through Sudirman Jamal, his father and his next friend as plaintiff. And okay, first defendant must be the police. Okay, you can put some people I saw, you put the lance corporal, not wrong. Okay, also can. But my preferred style is I don't put I just put the name because they are individual. You are suing them on personal capacity. They are personally liable for their action. Okay, so government of Malaysia, and then you put one underline statement of claim. Okay, start with this format. You have to first introduce the parties, and when you introduce, when you write your what we call paragraph, you have to put one, two, and then you have to do spacing. Spacing is uh, spacing. How to say in this bahasa Melayu, spacing. You have to enter
Jarak,
this. Huh?
jarak.
Ajaran, ya betul. Bagus awak. 1.5 1.5 line, You have to leave your answer sheet. You cannot just write the next sentence like that. Wow, like a jumble up everything. Cannot. You have to really follow this format. Every single marks count and every single details will be considered to when award you lah. Okay, first, do not just talk about too long. Identify what is the capacity of the party. I will say the first plaintiff known, okay, is Malaysian individual who resides in Pulau Bangkok. Full stop. Okay, that is the whole information I got. Wow, don't write at the you can say at the material time she was a student, but these are not so relevant. The second plaintiff is a Malaysian individual who resides in Pulau Bangkok. This one is important already because you punya apa? This one suing through Sudirman Jama. So you have to really make why you sue through Sudirman, isn't it? Because he suffered from a paraplegic condition at the material time. So the second plaintiff is a person under disability and suing through Sudirman Jamal, his father and next friend. Or if you want to use this word, you can do litigant representative. Okay? Sebagai itu litigasi representasi. Okay? Very simple, eh? And the identity of the first defendant. I will say the first defendant because I want to introduce the party already. I have no time. So I will not say he's an individual, but I will say he's a member of Royal Malaysia Police, PDRM, with his service address at Balai Polis Pangkor, because all that you don't have, isn't it? So from the police report and all that roadblock that his the facts given, you said so. So at all material time, the first defendant is what? The Lance Corporal of Police Forces. Okay, sweet and clear with jarak and spacing. And number four, the second defendant is what? Is the government of Malaysia whose service address is at me. If you want to sue government, you cannot serve to Datuk Sri Anwar Ibrahim. You have to serve to AG Chamber. Okay? You cannot write, oh, I didn't put Putrajaya and all that. The right service address is at Attorney General Chamber. This is the address. Whether you are interested to write sex also can, Putrajaya. Okay? At all material time, the first defendant is the employee of the second defendant. I introduce the relationship. So I put it this way, big my style, this is what my style. You can follow, you cannot follow is there's no big deal. Okay, I will put one backgrounds here. So what happened? I will need to state what is the facts given. So at around 9 p.m. on 9th of September, okay, I put it numerical form lah. This is also usually lawyer will draft like that. They will not draft 9th of September 2020. Okay, they'll put it this way. First plaintiff is riding the motorcycle bearing the number ACE quadruple 4 along Jalan Pasir Bogak, Bangkok towards Telok Nipah. So the second plaintiff was the pillion rider of the same motorcycle. Roughly, you you have to tell the story. You have to learn this one. You have to practice more. Then you can you can do the drafting very well by more training. Okay, so the first defendant was performing his duty in the course of his employment by stationing at the roadblock at or near Jalan Telok Nipah together with one Sergeant Ali, Corporal Abu, and Corporal Ahmad. So you introduce already, you start catching the points here. Okay, so open the detection of roadblock aforesaid. Both plaintiff made a U-turn, headed back to Bangkok town. The said action had attracted a pursuit by police officer. Okay, see or not? So this is the chronological event. The first defendant who was riding a motorcycle bearing the number of CAD 187 came abreast the plaintiff motorcycle and tried to kick it in order to stop it. The pursuit happened already. Okay, the first defendant managed to initially kick first plaintiff itu Nor right leg. Then the first defendant kicked again and managed to hit the right rear side of the motorcycle. Okay, so you have to put blame on the first, what we call the defendant, isn't it? See or not? So due to the kick, the second plaintiff lost control of the motorcycle. What happened? Next, both of the plaintiff were thrown from the motorcycle, okay, and sustained injury. Okay, injury. Very important, eh? Okay. Subsequently, use one heading, what you want to say. I will say what is the particular of first plaintiff. First plaintiff, still remember, eh? Uh, eh? First plaintiff is actually, no, it's actually this. Okay. I did make a change, but this one never changed. Wait. So, first plaintiff is actually the girl, isn't it? The girl was 16 years old, student at the time of the accident. That's why it's a freshly baked answer. Eh? She had suffered from a swollen and tender left cheek and a lacerated wound 1 cm inside the mouth. This one where I get is from the police report that the first plaintiff, No Binti Atan, made, Okay. So this one, I put it here in my statement of claim. Okay. That's why you have to read whatever information you provided to you. Cannot simply just or due to the said negligence, plaintiff suffer damage. But what damage? You tak plead? You tak plead? Tak boleh lah ni. During trial, during bicara, awak nak heboh-hebohkan. Tak boleh. Okay? So, you plead according to the facts given, whatever reports, whatever the documents that you have. Okay. So, particulars of the second plaintiff injury. So, the second plaintiff was actually 17 years old student at the time of accident. Now he had complete motor sensory neurological deficit. All that where I copy from is from the specialist report by Dr. Dushan. Okay, so copy everything and no need to think lah. Actually, no time to think also. Just copy here and put it nicely. Okay, so everything you said will be based on evidence. Okay, then subsequently you have to identify two parties, isn't it? You cannot say due to the fault of the two parties that the defendants then suffer loss. Full stop. Apa liabilities dia? Apa dia punya kesalahan? What is the civil wrongdoing of the defendant? So first defendant negligence or trespass ma. Second defendant is a vicarious liability. So you have to highlight what happened here. So I will put particulars of the first defendant's liability, such as intentionally kicking repetitively at the first plaintiff right leg and second plaintiff motorcycle, leading to injury. Okay, and then second, I will put directly kicking first plaintiff right leg, causing immediate injury to the first plaintiff. But this one is non-exhaustive. You can expand because due to limited time I just draft roughly according to my immediate understanding. So failure to act reasonably and avoid causing harm to others while performing his duties as a police officer. This one I want to plead what? I want to plead negligence already. Okay, breaching his duty by kicking a moving motorcycle in a pursuit constitute a dangerous maneuver. Okay, and deliberately disregarding the safety and interest of plaintiff. This one very general. Okay, and second thing, liabilities of the second defendant, government of Malaysia. Apa salah? So by employing the first defendant and also perform negligently. Okay, this one by right should be A woman. Woman. Okay. So to make it nice and sweet, later I'll make the correction. Okay. So liability is you employ this not performing or underperform staff, your fault. Okay. During the course of employment, this is the key highlight here. And provide uh, did not provide sufficient advice, training, and monitoring of the first defendant to deal with the pursuit situation. You tidak melatih you punya staff, bagus lah. That's why you are strictly liable. Okay, failure to provide a proper SOP in conducting a route block to ensure the safety of other route users. Okay, and then you submit as such, due to the aforesaid liabilities on part of the defendants, both plaintiffs suffer pain, injury, loss, and damages. Okay, then you have to go to particulars of your special damage. Just now we discussed, isn't it? Special damage are the general damage are the aggravated, all that non-quantifiable. You don't have to list. So this one, special damages, I will roughly write medical bills, berapa? Pre-trial nursing care from the date of accident until the date of trial, berapa? Cost of the what we call medical reports, police reports, sketch, etc. Berapa? Of course, you do not have lah. You cannot. You just put in ABC, okay, and loss of motor repair, not loss, repair or cost of motorbike, 500 ringgit, and subsequently you put in a total here, total RM XYZ. Okay, that one is my style lah. And the plaintiff claim, okay, the plaintiff's claim special damage in the sum of XYZ, aforesaid, okay, general damage, aggravated damage, exemplary damage, interest, cost, and then subsequently such further and other relief this honorable court deemed fits and proper to grant. Okay. And finally, you must date this one. Okay. What is the date? Okay. Take, for example, 6th of November 2023. Automatically, just memorize your date of examination and put. Okay. So you have to sign. You have to sign. Solicitors for plaintiff. Okay. And then you have to put in full. This statement of claim is filed by whom? Okay, third one, maybe third one ABC, the solicitors for plaintiff, whose address for service you must also write in full. Okay, what is your phone number? Okay, as simple as that. Understand?